Members.
各位好。
Good afternoon. This is the appointed time, and we have our quorum. So I call this meeting to order. This is the meeting of the Panel on Administration of Justice and Legal Services. Item 1. Information papers issued since the last meeting. The Secretariat has issued 2 information papers since the last meeting. Members, please refer to the agenda for details. Item 2. Schedule of meetings for the remainder of the 2025 session. We've proposed the schedule of meeting for the panel for the remainder of the 2025 session. Please refer to the schedule tabled. Subject to any other views, the panel will hold regular meetings on the 7th of July, the 8th of September, and the 6th of October on Mondays at 4:30 in the afternoon. All right, if there's no objection, third item. Items for discussion at the next meeting. Please refer to the list of outstanding items for discussion, CB bracket 2538/2025 bracket 1, as well as the list of follow-up actions, CB bracket 2538/2025 bracket 02. As per our discussion at the meeting of the 14th of January, the regular meeting in May will be held in April. Instead, is 4:30 p.m. the 28th of April. The administration proposes to discuss 2 items at the regular meeting as mentioned. The first one is the Law Reform Commission Secretariat progress on the systematic review of statutory laws of Hong Kong and cultivation of international first-class law firms and arbitration institutions. Right, if there are no further comments, let's move on to the next item. The next item is work plan and progress of rule of law education and promotion. Let me invite the administration and the representatives to come in. Please refer to the paper provided by the administration, Department of Justice in particular, CB bracket 2538/2025 bracket 03, as well as a background brief prepared by the LegCo Secretariat, CB bracket 2538/2025 bracket 04. Members, if you want to speak, please press the request to speak button now. Right, we're joined by Secretary for Justice, Mr. Paul Lam, and his team. Welcome. We've also invited Mr. Charles J. Chan, Bar Council member of Hong Kong Bar Association, as well as a representative from the Law Society of Hong Kong. Secretary, when you're ready. Thank you, Chairman. Chairman, members. Under one country, 2 systems, the robust rule of law is the cornerstone for Hong Kong's long-term prosperity and stability. We also attach a lot of importance to the rule of law education. Taking a multi-pronged approach, we seek to deepen the society's understanding of the rule of law. And we set up the Steering Committee on Rule of Law Education. We also have rolled out the Role Stars Train the Leader program, TTL program. I'm happy to be here to brief members on the achievements achieved so far. Now, the program, as at the end of 2024, had seen 290 trainees completing the program, 250 in fact completing the course, and these trainees have come from diverse backgrounds. They are representatives from 21 organizations related to youth work and teachers from secondary schools. And 250 trainees have successfully completed the foundation course. According to the feedback, we have received positive feedback, and most of the trainees are satisfied with our training program. They are also interested in joining the advanced course activities. We feel encouraged. In the first two phases, we've achieved success, and riding on this, in 2025, the DOJ will roll out the third phase of the TTL program. It covers 3 parts. That is organizing a new round of the foundation and advanced courses, as well as a new extended course. Now, on reorganizing or running a new round of the foundation, riding on the previous cohort, we will fine-tune the curriculum. We will share more real-life examples and cases, and also give more examples in relation to court proceedings, so as to enhance the trainees' understanding of the system. We also will be recruiting approximately 120 young members of district youth committees and tertiary students to pursuing the education discipline to join the foundation course. For the former, they play a pivotal role in promoting the rule of law in the community, and for the latter, they also play a critical role in advancing the rule of law education in schools. So we want to lay a good foundation. The next component is advanced course of the TTL program. Again, riding on last year's success, we will include visits at law enforcement agencies, police stations. There will also be mock court activities and trial sessions to enhance the trainees' understanding of court etiquettes and procedures. We plan to recruit 80 trainees to join the advanced course. The third component is extended course, which includes thematic talks and practice activities for the promotion of the rule of law. For thematic talks on specific legal topics, we'll focus on common cyber crimes and common online civil disputes. We encourage trainees to learn about the real-life examples and apply what they've learned in real life. The first talk, in fact, was successfully conducted on the 22nd of March with the attendance of more than 50 trainees. We received positive feedback. The second talk will be held in the fourth quarter of this year. Now, apart from the thematic talks, we also require our trainees to complete certain hours of practice activities, such as being the facilitators of the foundation course. They are also required to submit a report to our department to tell us how they've learned the acquired knowledge of the rule of law, so that they can convey the acquired knowledge of the rule of law to their peers and gradually build up their confidence in disseminating this concept. In order to encourage the trainees and the learning of the rule of law, we will also set up or establish role ambassadors. There will be also other rule of law education programs. Now, for primary students, we will continue to take forward activities including rule of law through drama and the drama day. In fact, in May, between the 3rd and the 4th of May, we plan to hold a large-scale rule of law drama day at the Hong Kong Cultural Centre. Our target is to recruit or to have an attendance of about 1,500 people, including parents and teachers, so as to instill in the minds of primary school students and parents the concept of the rule of law. We also have a guided tour of landmarks of the Hong Kong Legal Hub. It's called the Rule of Law Journey. We provide about 10 such activities, 10 sessions for the participants to learn more about the Legal Hub and the rule of law. We also continue to mount publicity through diversified channels such as short videos, online websites, social media platforms, etc. Looking ahead, we'll continue to work closely with the relevant government departments and different stakeholders to pass on a law-abiding culture and consolidate our excellent foundation of the rule of law through diversified programs of the rule of law education and promotion, and thereby joining hands in bolstering the rule of law in the community. Next, let me invite Mr. Charles J. Chan, Bar Council member of the Hong Kong Bar Association, to speak. Please speak not more than 5 minutes. Now, the Secretary has delivered a very detailed report, and it seems that positive feedback has been received and the results are really encouraging. From foundation course to advanced course, the TTL program now covers the third round or the third tier, that is extended course, and I feel encouraged. My question for the Secretary for Justice and his team is this. Can the administration explain more about the foundation course and advanced course? At the moment, I see that the expected number of trainees is 80. What factors do you consider? Has it to do with implementation or design of curriculum so as to set this fixed number? And also about those progressing from foundation course to advanced course, is the response within your expectation? Thank you. Next, Ms. Sharon Tam, Chairperson of the Teen Talk Organizing Committee 2025, the Law Society of Hong Kong. Please also speak not more than 5 minutes. Chairman, members, good afternoon. I am Chairperson of the Teen Talk Organizing Committee 2025 of the Law Society of Hong Kong. I'd like to brief members on the Law Society's initiatives in promoting rule of law education, especially education initiatives targeting young people. Starting from 2009, we set up the Teen Talk program so that with interactive and interesting activities we could disseminate important legal messages to secondary school students and to cultivate their interest and knowledge in laws, as well as to enhance their critical thinking. Now, it's one of the flagship events of the Law Society of Hong Kong, and so far, over 470 schools and 18,000 secondary school students have joined. In the past decade or so, through Teen Talk, young people have acquired a lot of knowledge on our laws and our law enforcement efforts. A major feature of the Teen Talk is that members of the Law Society are bona fide mentors, and through interactions and discussions, they help students understand the legal concepts and how they can apply to day-to-day activities. Now, in 2024, let me highlight a number of important events. For example, for the first time, the Law Society held an exchange tour in the Greater Bay Area, and it's a 2-day, 1-night itinerary. Law students spoke in English and exchanged their views with students in the mainland and as well as students in international schools. They visited a number of legal institutions and major tech firms such as DJI in Tianhai. They also visited the International Arbitration Court in Shenzhen. They learned about the difference in the legal systems in two places, as well as how laws are applied. They also took part in a debate competition to know more about our role as an international city in the super connector. We also have a mentorship program under Teen Talk. In 2023 December, we started the mentorship program. We recruited 50 lawyers and 120 candidates. We also had different activities. We visited the Fire Services and Ambulance Academy, and we also visited the open day of the C&E department so that our candidates could learn more about law enforcement. And there was also a speaking contest for candidates to know more about the harmful effects of drugs, trafficking, drug abuse, and other related matters. We're going to roll out a new round of activities in 2025 to further hammer home this message. We're going to hold the exchange tour in Greater Bay Area again. We'd also like to roll out a new mentorship program so that we can help groom our next generation to learn more about the legal knowledge.
All right, thank you for the points made by the relevant representatives. I'll now open the floor for members to speak. Mr. Tang Fei, thank you. I am glad to see that apart from the foundation advanced courses, there will now be an extended course. So will that be open to youth leaders to take the course, or would it be open to teachers of schools as well to take part in? I believe youth leaders in district committees, they will be more interested in the pragmatic issues, but for teachers in schools, they may be more interested in constitution and basic law. I think with the rule of law education, would you change the curriculum, tailor-made it to the target groups? For those who are trained, will you follow up on them? Would you set some target or goals for them to meet after taking the program that they have to promote to their communities, or the number of activities that they must hold after taking the course? Thank you. 2 questions, Secretary. Thank you, Mr. Tang, for your questions. I would say this. We have been holding the foundation course for 2 years. We have been telling people through these courses the basic concepts of the laws of Hong Kong. That would also include knowledge relating to the Constitution and the basic law. And these will be useful for not only the youth district leaders but also school teachers. So the curriculum has been more or less similar for the past 2 years, but we have made some minor adjustments with the curriculum. In the first year, we had more of youth district leaders taking part in the course, so we have adjusted the content to their work. And for the second year, we have all of the students being secondary school teachers, and we know that they have to teach students knowledge in the laws of Hong Kong, which is why we have adjusted the background information for the courses. So this TTL program is to train the leaders. We want to pass on the knowledge to the students or those taking part in the program, and then they can pass it on to their service targets, say students. We now have, on top of the advanced course, we have the extended course. There is a practicum component. So for them to take the course, they need to be imparting such knowledge as ambassadors. And from the feedback we got, we do not have the implementation details for the role ambassadors just yet, but the participants have already been making use of the knowledge they learned in their daily work. But through the practicum component of the extended course, we believe we will be able to truly achieve training the leaders in the community to promote rule of law education. Thank you. Next to speak, Mr. Martin Liao. First of all, I would like to thank the DOJ for their multi-pronged approach in promoting rule of law education. According to the paper, the third phase of the TTL program, that is the last phase, has been launched. And the program is to train leaders in different sectors of the community so that in their daily work they can promote rule of law. I want to ask the DOJ, upon completion of the first phase, did the DOJ review the effectiveness of the program? Can these leaders train or impart the right knowledge to the public? Honestly, I haven't seen many studies in the area recently. Has the DOJ conducted relevant studies and reviewed the effectiveness of the program to see if it has truly enhanced public awareness on rule of law? Third, the extended course would have a practicum component that would have a set number of hours to complete, that would be say, holding rule of law activities. I think this is good because I think that wouldn't have to have the DOJ organize all activities relating to the promotion of rule of law. But the participants of the extended course may not have experience holding events, and we need to make sure the knowledge imparted is accurate. It may be difficult for the participants to hold activities on their own. Will the DOJ help the relevant participants and organizations hold relevant activities? Thank you. Secretary. The first question was on effectiveness on the program. We have held not less than on 2 occasions meetings with the past participants to get their feedback. Say if they have managed to share what they learned with their service targets. From what we got, we are not trying to quantify things, but qualitative wise, they have managed to do that. It may be hard to quantify the effectiveness, however. We haven't conducted any territory-wide surveys, to be honest, and we do not have plans of doing that. It's not that we don't want to do that, but we just think it would take much time to conduct the surveys, to think about the different forms of surveys are going to take. I think there is a need for that, but we need to make sure it is done effectively and efficiently. Right now, we're relying on communicating with past participants, that is, the leaders of uniform groups or teachers, to get their feedback. If they have done more in the promotion of their rule of law education upon taking the program, we believe it would already be an achievement. But we will definitely consider your suggestion. As for implementation and the practicum component, everyone has different experiences. They may have already experience in organizing activities. Some, of course, are not as familiar with holding activities. We do not have the implement details for helping the role ambassadors just yet. We won't leave them be, that's for sure. We need to make sure we're imparting the right knowledge, as you said. We need to communicate with them often, and if they need any help, we can definitely help them, provide them with the right support, because that is how we can achieve what we intend to do. That's it. Thank you. Next to speak, Mr. Benson Luke. Thank you, Chair, for letting me speak, despite the fact that I'm not a member of the panel. I have all along been keeping close attention to youth development and to make sure the participants can share what they learn in the program. The TTL program, I have seen some good results so far, and I do support the DOJ's efforts. Ms. Sharon Tam talked about the Teen Talk program. I myself actually participated in some of the activities of the program as well, and I have seen good results. I have 2 questions on training. I would say recruiting more secondary school teachers to take part in the program would be good, because I believe with secondary school teachers communicating with students, we can do well with a rippling effect in promoting rule of law. And we already have some 100 teachers taking part in the program. How can we invite the other secondary schools take part in the program? we already have 100 secondary schools participating in the program. How can we get the remaining 400 schools to take part in the program so that more teachers will know rule of law better? I also note in the paper that there will be approximately 120 young members of district youth committees and tertiary students who are about to join the foundation course, and they will definitely help promote rule of law. And we do want them to make use of knowledge they learned in the program. Can we have, say, through the MSSY member self-recognition scheme for youth, to take part in the program, the TTL program? Because right now, those under the MSSY would take part in the work of advisory bodies. I think if they can obtain more knowledge through the TTL program, that would definitely help with their work. And we are also about to scrutinize the post-secondary colleges bill. There will be changes in the compositions of school boards. I believe with increased youth participation, we will have more youth members. And if they can impart knowledge in rule of law to the different members of the different bodies, that would be ideal. Thank you, Secretary. For secondary schools teachers, I know that there is demand for them to take the program. Unfortunately, we cannot meet all the demand at the moment. Let me talk about for the previous year's foundation courses. We have in the first year invited leaders of youth uniform groups to take part in the program. We want to have a group of people that had a similar background because we can focus our content to meet their needs. And for the second year, it would be just the secondary schools teachers, as Mr. Benson Luke said. In the third year, this year, we want to do half of which would still be district youth committee members, because there is great demand for them that we were unable to meet in the first year. So we want to meet that demand, but we also want to serve a new group of people, that is those who are undertaking programs in education, tertiary students. So we want to test out different groups for our participants. We have limited resources, but we also need to set a cap on the number of attendees because we want to make sure our program activities are effective, that they can reach out to the participants. And we have been liaising with the Education Bureau. In fact, a representative of the Education Bureau is also a member of the steering committee on rule of law education, and they have been helping us find the right target groups, and we want to make sure we are meeting the needs of teachers. As for your next question, for youth district committee members or for those under the MSSY, they may be interested, but they are already participating in other work of the government. I think it would be more ideal if they think through their different work opportunities, they can already impart knowledge in rule of law. That is probably a more appropriate approach. Well, depending on their actual work, which body they're working with. But anyone interested, we'll try to accommodate them, but we need to set up priorities and to make sure there is efficient resource allocation.
Next, Monsieur Nation. Thank you, Chair. I support the Department of Justice in promoting rule of law education. I understand that there are different programs and training initiatives, including those at the district level. Youth leaders, including university students in the education disciplines, will be trained. I think it's a good idea because they will become teachers. So from the young people's perspective, they can impart knowledge to other young people and tell them their first-hand experience. Now, I also took part in some of the guided tours. We visited courtrooms, but for the Court of Final Appeal, as I understand, is not yet open to the public. In the past, we were allowed to visit the CFA. And I understand that starting from May, some of the court proceedings at the level of the Court of Final Appeal will be broadcast online. Again, I think this is a good education initiative. The government should leverage on live broadcasting to educate the public about the rule of law. Now, of course, lawyers understand the proceedings, but for laymen, I think we need somebody to interpret the proceedings for them and educate them about the proceedings. So my question is whether resources are available so that since we have this ready-made education kit here, we can combine the live broadcasting and the training program so that we can step up our efforts in educating students and that the audience will have a better idea of the bone of contention in courtrooms. Meanwhile, we should also leverage on the uniformed groups, including the CSD, Youth Corps, etc. As I understand, they have the path of reflection. They also have similar initiatives. They can tell the stories firsthand because they are at the front line. They understand the latest crime trends, and they are more in touch with the young people. So I hope the Law Society will work with the uniform groups as well as law enforcement agencies, youth corps. As for a drama program, apart from live performances, I hope that the video clips can be produced so that both offline and online the audience will be able to watch the excellent performances, especially for those who have taken part in the drama and plays. Just very briefly, I agree with Ms. Eunice Yong that these are some of the very good ideas. In fact, starting from the 1st of April, not mid-April, live webcasting of court proceedings will happen. That includes not just the CFA but also other appellate procedures. Now, is it possible to keep them on, keep recordings? I think it's different from normal proceedings because the Court of Final Appeal usually deals with more complex and in-depth points of law. But of course, the broad principle is to utilize existing resources as much as possible. The second point is about uniform groups. In fact, we do work with them. The first phase, as I mentioned about the foundation course, is the disciplinary forces, youth corps, and youth uniform groups. We have these youth corps from the FSD, the CNE department, etc. They are our core supporters. They have given us a very positive response. As for the drama, as I mentioned, this year we're going to hold a large-scale drama event. In fact, there will be a roving exhibition of this play at primary or junior primary schools, the other one and senior primary schools. Well, because I think the drama itself is quite a good idea. We can expand the campaign, and we can also invite more schools to take part in the process so that we can enrich the content. As for making video recordings of the play, well, we need to have regard to the IP issue, but I'll give it a thought. I wouldn't say it's impossible. But my feeling is that usually the drama comes with the interactive session, and that's really the most impressive part for our children. Professor Priscilla Leung. Thank you, Chair. First of all, I support the government's rule of law education and promotion efforts, especially at the community level. Now, I haven't been given this chance to say this, but let me share with you here. For our young people, well, there is major drama program. Young people can perform in the drama, or they can at least watch it. We also have training for secondary school students because they need to be educated about the national security law as well. Now, I'd like to share the following. When I was first when I became first became a district, or became a councillor, I always took part in the so-called mock trial sessions for people in the community, for schools. There is a lot of role play involved. You know, the students would become court reporters, they would be plaintiffs, defendants, judges, and even parents took part in the process. The topic could be quite straightforward: a simple theft or theft by finding. That is, you picked up a wallet off the street, and how should you deal with this wallet? And I've been doing it for many years. It has been a very popular program. Over the years, I have worked with different schools, and I even brought in my own law students. Now, having done that for so many years, what I'd like to share with you is the parents' feedback. I've been told that their kids are now much more obedient, and they study much harder, because in order to read law, you need to be good in English and in Chinese, and it's all about the values nowadays. Parents often fail to catch up on what their kids think, so you need to start instilling the correct values in the kids' minds. You need to explain to them the importance of the rule of law. Without the rule of law, we resort to violence, and we become a lawless place. Now, I want to share this experience with you, because in the past, reading law was a valuable opportunity. There was a lot of competition, but nowadays there are more and more choices for our students. You can study AI or fintech. There are lots of disciplines and subjects that compete with each other. For those aspiring to read law, I think we should work on them much earlier. A student who has taken part in the drama program for a few days would have some major changes. I think we can take a light-hearted approach, and this can be achieved in many schools. Now, recently, one of my colleagues also joined this steering committee on the promotion of rule of law education. I think we can all chip in, but what is more important is to allow more people to gain first-hand experience, and that will drive a major change among children as well as parents, and that we can further enhance our rule of law. Any response, Secretary? I'd like to share with you a similar experience as well, albeit in a different scenario. A major component in the advanced course of the TTL program is to invite these leaders to take part in a mock court activity. In other words, after sitting in for the lecture, they need to get their hands on the actual scenario. In other words, in this moot court, role play is involved. Our candidates would be the lawyer or witness, and in fact, on the last occasion, I was cross-examined as a defendant. So the concept is that we want to provide practical experience. We want them to be able to apply the knowledge they learn, and not just theories, but also practice. And we also instill in them some very important rule of law concepts, such as a party's right to be heard, and that we need to give the audience to all the parties in court. So, of course, becoming a lawyer is one of the achievements, but what is important is to instill in the minds of people the rule of law's concept, and that through the advanced course they have the practical experience, and as leaders they can then convey the knowledge of the rule of law in school to other students, for example, and that they could set up their own mock court or moot court in their own schools. They'll be more confident in doing so. That's the objective of training the leaders. Next, Mr. Holden Chow. Thank you, Chairman. We strongly support the work plan of the rule of law education and promotion. Let me turn to role ambassadors in paragraph 19. The DOJ will be launching role ambassadors. And my question is this. It's a very short paragraph here, but may I know more from the Secretary? How exactly will the DOJ launch the role ambassador program? Will there be different phases, or at the first phase, how many ambassadors do you intend to recruit? Because as mentioned in the paper, 120 district youth committee members will be recruited. Can you tell us more about the role they will be playing and the division of work, please? Thank you, Chairman. Let me elaborate on what's set out in the paper. There are 3 phases or 3 tiers of the TTL program. So foundation course, advanced course, and extended course. In order to become a role ambassador, one must complete all 3 courses. What's crucial is that in the third phase, the extended course, you need to put words to practice. That means you need to take part in some activities to show us that you can be a leader in terms of the rule of law education and that you have actually acquired knowledge. So we are finalizing the curriculum of the extended course. We need to consider, for example, what a teacher needs as a candidate, or what a uniform group member needs, because their needs may be different. A teacher may need to run their own activities in schools. So, as I mentioned, we will require trainees to submit proposals so that we can advise them what to do. Now, after completing the 3 courses, that means a trainee has passed the quality assurance, so to speak, and that's a Q mark. They will continue to take it forward and disseminate what they've learned to others. Now we have the role ambassadors initiative. Maybe later we can set up an alumni club. We can also leverage on the newcomers and the graduates to help us promote rule of law education. We will announce the finalized plan in due course. Our target is to complete this within this year, because we need to complete the extended course within this year. So in due course, we will further explain to the public about the role ambassadors.
Dr. Julius Ho, I've been listening to what is said for quite some time. I think we're being fake about what the goals are, and we need to have a goal-oriented approach. We want to promote rule of law. We don't even need to talk about children. Even practitioners, they don't know enough. What can we do more in enriching the content of the program? I have a few suggestions. You talked about it being hard to quantify the effectiveness of the program. You have 3 phases of the program: foundation course, advanced course, and extended course. What foundations are you laying in the foundation course? I think you need to set KPIs before one can progress onto an advanced course. And what are the performance goals of an advanced course? If you're saying phase 1 would be 1 month, advanced course would be 2 months, and extended course would be 3 months, that is not goal-oriented. I would say this. For the DOJ to do something so elementary, it's a waste of your talents. For the 20 follow-up initiatives, 5 to 6 of them would relate to arbitration and mediation. It is our way to manage risks and to develop Hong Kong into a dispute resolution center. We also have the IOM set up headquarters in Hong Kong. These are achievements. For the TTL program, it seems minute in comparison. Law Society has been holding relevant activities for many years. And in the functional constituency of law, there are 30 organizations that can vote, and all of them are elites in the area. Why can't we leverage on the efforts of the organizations? I mean, those in the DOJ are receiving very high salaries, and you're just wasting your time on these minute miscellaneous programs. I think it's a loss of focus for the department. Why not engage the Bar Association or the Law Society and have them hold the activities, and they will have a more focused approach. I think first you have to set KPIs. 2, you need to create synergy by working with the organizations. You shouldn't rely on your own efforts, because as a Chinese saying goes, we need to work with others to make sure we're clapping with noise, because one hand alone cannot clap, right? And with the curriculum, I would say this. There should be targets set for each course, each phase, and certificates should be issued to participants. It's just like before one is admitted to a kindergarten, one has to go to prep school, and they would be issued with certificates telling the kindergarten interviewers what the students have learned. I'm not saying we should train lawyers through the program. We need people to know about the legal system. If they eventually go into law, would the certificates of the program, or would taking the program would help with admission into law programs? We want to make sure we are achieving something with the efforts. So now we have to be more specific. Next, the chief executive talked about making sure our efforts will be seen. And students would need to know the Constitution and the basic law. In fact, the teachers would also have to know them. They would also have to know what the national security law is. And Presidency said the basic law is good, so we need to at least know what the basic law is about. I think you can impart more concrete knowledge in your curriculum so that the participants will know what they're going to learn in the program. And for participants, it may be easier for them to say what they have learned in the program, and they may even tell their parents if it helps with their admission in law in future. That would be nice. I think the DOJ should take a more macro, high-level approach. You should work with organizations, assign work to the organizations. You only have to help with coordination. That's my suggestion. Chair, I would say this. For the Department of Justice, how much money are they allocated with the holding of the program? The Law Society members are unpaid with the holding of these activities. We can definitely leverage on the resources rather than relying on the DOJ officers who are receiving very high salaries to do such work that is just wasting their talents. I'm not saying the Law Society is free, but then I would say that they have all along been undertaking such volunteer work, and we should rely on their resources. Thank you. Secretary, thank you for your comments, Dr. Junius Ho. I think Dr. Ho is probably not familiar with the contents of the TCL program, so let me clarify something. I would first disagree that this is miscellaneous work. I will explain why, but I respect the stance of Dr. Junius Ho. This is not a program for children. This is a Train the Leaders program that would we have to enhance public awareness on rule of law education. We need to tell people what the Constitution is, why the national security law is important. We think everyone should know about this, but we cannot hold a course for all 7 million people of Hong Kong, which is why we want to have some target groups, say teachers and youth leaders. They are in a good position to impart such knowledge to other youngsters, which is what we want to do through this program. And in the foundation course, it would include a national security component. It would have knowledge on Constitution and the basics of the laws of Hong Kong, as Dr. Junius Ho mentioned. And most of the speakers aren't from the DOJ. We actually had Ms. Sharon Tam from the Law Society of Hong Kong, who is a keen supporter. We have also engaged barristers, judges, and many of those from the relevant organizations, really. It is an initiative of concerted efforts. I hope Dr. Junius Ho would understand that to uphold rule of law, we not only have to facilitate, say, the IOM setting up regional headquarters of Hong Kong, but if we are to develop into an international legal and dispute resolution center, we need to make sure our society has high standards in rule of law, and we need to do more in the basics. With the development of international legal and dispute resolution center, the core is to consolidate citizens' foundations in rule of law. We had our experience in 2019. Something that we thought should be common knowledge seems to not be common knowledge. And we want to, through this program, to enhance general awareness of the public in rule of law. And through such training, we have imparted such knowledge. We have the support of other departments and the relevant organizations, the Bar Association and the Law Society. We have also received positive feedback from the participants. We believe our direction is correct, and we will continue our efforts in this direction. We also note Dr. Junius Ho's suggestions, and we will enhance our program. Thank you. What I'm saying is if my suggestions are useful to the DOJ, they can take them. And in fact, they are already doing certain things that I suggested. Then I would say this. It is very important to quantify things. For example, if we can issue certificates with benchmarks, what are the benchmarks met? I think that will be useful, especially for youth leaders. And professionals can also be leaders. I think if we are to enhance our reach to the leaders, that would be helpful. You also want to engage promoters, which I understand. I think the common goal is to enhance the promotion of rule of law. But what I'm seeing here is there's much room for the creation of synergy to enhance your efforts so that in future the leaders can probably walk confidently in the path of law. Any response from the secretary? I very much welcome any suggestions from members. Thank you. I believe Mr. Charles Chen asked a question. Will you address the questions? If I repeated it wrong, please correct me. Why did the DOJ set the cap of attendees to be 80? Well, it's not that we set a cap at 80. It's just that those in the foundation course cannot really take part in the advanced course due to their commitments. We have some extra components in the advanced course. There will be a mock trial, there will be specific classes and activities. Apart from court visits, we have also arranged for activities with the law enforcement agencies. So we have engaged those who have undertaken the foundation course, and if they are interested and can take part, they will be invited to the advanced course. So this number is derived based on the allocation of resources we have at the moment and participants' interest. Thank you. All right, that's the end of the discussion of this item. We will move on to the next agenda item, latest developments of the family justice system. Yes, Dr. Junice Ho. I think with the creation of synergy, how much budget does the DOJ have? Can they work with the NGOs to do more? I know that they're working together, but can they do more to support the Law Society? I know that the Law Society has resources, but we shouldn't spend everything that they have. Say the Bar Association also wants to take part, and if we shouldn't ask them to work only pro bono, right? Well, I've already ended discussion of this item, but since Dr. Junice Ho is asking another question on the item, can you provide a response? Excuse me, I think I didn't answer the question of Dr. Junice Ho on resource allocation earlier. There's no specific funding. We have subsumed this program's funding under the LIDO. So this is just recurrent funding, really, we've been using. We do not have specific funding for the projects. We have just been trying to make good use of the funding to hold different activities. Let me also take this opportunity to thank relevant organizations who have worked with us to implement the program so that we can hold various activities without spending much resource. That's what I want to add. Thank you. Thank you. The next agenda item. Let's invite representatives of the administration, judiciary administration, to come inside the conference room, as well as the relevant representatives from the organizations.
Members, if you want to speak, please press the request to speak button now.
好，我而家先邀請
Let me invite Ms. Esther Leung, Judiciary Administrator, to walk members through the paper. Thank you, Chairman. Today's discussion is on latest developments of the family justice system. All along, the judiciary has deployed different measures to enhance judicial efficiency, including reform or amendments to the Family Procedure Rules, FPR, implementation of Family Master System, and enhancement of family mediation. Now, these are already highlighted in the paper. First, on the family justice system or family procedure rules reform, the rules cover the family and matrimonial cases. At the moment, these cases are dealt with by the family court as well as the high court. The relevant provisions governing the legal proceedings are fragmented and scattered across different ordinances. There is a lack of a single unified set of rules, and that is why we want to amend the FPRs. Following the enactment of the FPO, it was passed in 2023. We've set up the Family Procedure Rules Committee. At the moment, we are drafting the relevant procedure rules. It is a consolidation of the powers, all provisions relating to the powers, jurisdiction, and procedural matters governing these cases. And it's very complex. Time is needed for us to do in-depth research and consultation, and more time is needed for us to complete this really complex task to maintain consistency and coherency. We strive to complete the drafting process by 2026-27 for public consultation, and following public consultation we will submit the proposal to LegCo for consideration. In light of members' views expressed when examining the Family Procedure Ordinance, or the bill, the judiciary in November last year invited the social welfare sector to express views in relation to the major proposals. Now, there has been a general support for this legislative exercise, and we will also consider all the views collected to improve the procedures as well as other matters. The next point is the Family Masters System. The FPO provides legal backing to the establishment of the Family Masters System. The system was implemented in October 2023, and with that, the judicial manpower also increased correspondingly. Under the Family Masters System, masters could deal with case management so that family judges can be spared to focus on substantive case hearings. In fact, it's an enhancement, and since implementation, things have run smoothly. The waiting time has also been shortened. Next, about family mediation. On top of the FPO and the Family Master System, we've also been promoting family mediation. Starting from 2019, the judiciary has been implementing the Mediator-Assisted Financial Dispute Resolution pilot scheme for helping divorcing parties in appropriate matrimonial cases to resolve their financial disputes through mediations. This can help shorten the time for litigation. And in March 2024, the Family Court Annexed Mediation Scheme was introduced to assist litigants in person with limited means to resolve disputes. Now, these measures are set out in today's paper. We've also provided the relevant statistics, and please refer to the paper for details. The judiciary will continue to adopt the multi-pronged measures. We'll also keep in liaison with the legal professions as well as court users. We'll continue to listen to their views to enhance the family justice system. Let me now invite Mr. Jonathan Mock, Chairman of the Family Law Committee of the Law Society of Hong Kong, to say a few words. Right, there are 3 highlights. The first one is about the Family Procedure Ordinance. Now, from the Law Society's perspective, we find merits in the proposal because on this occasion, a unified set of family procedure rules will be provided for court users to be able to resolve conflicts with clarity, since there are rules to follow. As I understand, the Family Procedure Rules Committee was established in September 2023, and since then, only 1 meeting has been held. The committee comprises members from different backgrounds, including the Law Society. Now, as far as the law is concerned, it's rather complex. There are 60 parts, over 1,000 pages of the rules. But as I understand, only 3 batches are now available. We're not sure how many more batches will come on stream. Now, the problem is, we know that there are 60 parts altogether, but in one batch it may comprise different parts. And according to the paper, the judiciary would like to complete drafting of the FPR by 2026-27. The crux of the matter is that we're not sure, on top of the 3 batches, how many more batches will be produced for the Law Society or the Bar Association to give advice. We want clarity as to how many batches there are in total. We all want the process to be completed as quickly as possible. The next point is about the mediator-assisted financial dispute, the Family Court Annex Mediation Scheme. I think that this is a pragmatic approach since assistance will be provided to litigants in person with limited means. I think mediation is very useful for family and matrimonial cases. In fact, there are also other initiatives that lawyers participate in, such as the Mediator-Assisted Financial Dispute Resolution Pilot Scheme, or MFDR. This allows people to be represented legally, as well as the mediator to give advice. And this is quite a unique mechanism for Hong Kong. It's not common elsewhere. Now, the final point I'd like to make is that mediation is, after all, about reaching an agreement by both parties. The Law Society continues to support mediation efforts. As for the family court and the family masters system, we are one of the court users, and apparently the system could speed up the waiting time, and many masters are really hardworking. Very often they go through all the necessary papers to make sure that the proceedings can be completed as quickly as possible. So I agree that the family masters system is helpful.
The Bar Association, Mr. Warren Adjutant, to speak on this item.
Mr. Chairman, apologies on behalf of Mr. Eugene Yim, who was going to be addressing but unfortunately he's remaining in court, which I suppose illustrates how busy the family court is at whatever it is, quarter to 6. We thank the Judiciary Administration for reporting on the developments and reform relating to the family justice system over the past period of time. In relation to the drafting of the family procedure rules, we understand that it takes time to draft and compile. There are representatives from the Hong Kong Bar Association to participate in the work of the Family Procedures Rules Committee. Last year, the Judicial Administration jointly organised with the welfare sector an engagement session, and the Hong Kong Bar Association sent representatives to provide assistance. We hope that the family procedures rules to be introduced in the future, in conjunction with the already implemented family master system, can effectively enhance the efficiency of the family justice system. The alternative dispute resolution mechanism is, of course, also a project that the Hong Kong Bar Association is concerned about and supports. the mediator-assisted financial dispute resolution pilot scheme has already shown results and has gained strong support from the legal profession, including both barristers and solicitors. We are aware and pleased to see that the Family Court Annex mediation scheme will continue to be promoted, and we hope these measures can help more clients involved. The HKBA will continue to support the judiciary on the family justice system as always. Thank you, Mr. Chairman.
Thank you, Mr. Adjutant. 現在係議員嘅提問時。
All right, the floor is now open. Let's start with Ms. Maggie Chan. Thank you, Chairman. My question is on family mediation. I learned from the administration's paper that there are two pilot schemes. The first one is Mediator-Assisted Financial Dispute Resolution Pilot Scheme, or MFDR. The next one is Family Court Annexed Mediation Scheme, or FCAMS. Data are provided for the two pilot schemes. Now, according to paragraph 16, in 2024, a total of 50 cases were arranged to go through mediation, and 42 cases, agreement were reached. The next one is the the Family Court Annex Mediation Scheme. It was introduced on a pilot basis in March 2024, and it achieved a success rate of about 93% in 27 cases. That seemed to be quite a high success rate, perhaps somewhat different from the settlement rate of the former pilot scheme. In fact, there is also another pilot scheme under the Home Affairs Bureau relating to mediation of maintenance payments. Now, according to the Secretary for Youth and Home Affairs, starting from October last year, 64 cases were successfully mediated under that pilot scheme. So in terms of this maintenance payment scheme, mediation scheme, again, that sounds successful. So I'd like to know exactly how these three schemes fare. Is there any difference? Now, the second question is that there are different government departments, the judiciary, and the Home Affairs Department, the Home, etc. I want to know whether there is any coordination as far as mediation schemes are concerned, so that we can tell the parties involved all available avenues, and also whether there are KPIs in relation to the two pilot schemes I mentioned. JA. Thank you, Chairman. Now, to answer members' question, for Family Court Annex Mediation Scheme, we're talking about cases that have reached the court and that suitable cases will be referred to undergo mediation so that the matter can be settled by alternative dispute resolution instead of going through court proceedings. We find this to be a very effective way in cutting time, resources, and costs. Under the pilot scheme, even after the court issues an order, you still need to make sure that the order can be enforced. The other pilot scheme is the Mediator-Assisted Financial Dispute Resolution Pilot Scheme. This refers to divorce petitions submitted to the judiciary, and that for the judges dealing with these cases, they may invite a mediator to deal with this part in a case and see if it can be settled through mediation. And the mediator is required to report back to the judge its progress and seek direction. Now, the success rate is actually quite high because it's the court that picks the suitable cases to seek mediation. As for paragraph 17, This is a new scheme. This is akin to a duty mediator scheme. It covers not only financial disputes. At the call-over hearings, the presiding judge may consider the nature of the case and the financial means of the litigants, and considering all the circumstances, if deemed suitable, the court may send the parties to a dedicated mediator free of charge to have the case settled there and then, and indeed the success rate is quite high. So we'll observe these two schemes' implementation for some time, and if the success rate maintains high, we will continue.
Ms. Maggie Chan, any follow-up questions? I have a comment to make for the family justice system. We have seen legislation being scattered, and now we have a piece of consolidated legislation. I think for family mediation, on the other hand, we need to also have a consolidated initiative in promotion for people to consider the right option for them. So you have a consolidated framework for the family justice system, but you don't have a consolidated framework for family mediation just yet. That is not ideal. I hope that within the government there can be better coordination and promote family mediation. You can consolidate the dissemination of information on the different schemes available for users. Thank you. I have something to add. For the family procedure rules that we have been drafting, the 60-part rules, we have a dedicated chapter on alternative dispute resolution. We hope that with the dedicated chapter, it will be of reference to practitioners as well as potential users to let them know what options are available. In terms of administrative arrangements, the court in Wanchai, we actually have an integrated mediation center, and if suitable, people can go to the center and the integrated mediation office, and the users will be informed of the options available to them. This is the approach that we'll continue to take. Chair, I have another follow-up. I think publicity and promotion are very important. I think we need to make sure people know of the different options available to them. I understand that the family procedure rules are being drafted, but then they will only be completed in 2026-27, and then you have to consult stakeholders, and then you have to go through the Legislative Council. I think we need to hasten our progress by bettering coordination and publicizing family mediation in the meantime. Thank you. All right, next to speak, Ms. Kamen Khan. Ms. Kamen Khan, sorry, I said the surname wrong in Chinese. Excuse me. Thank you, Chair. I would like to echo on the point made by Ms. Maggie Chan on the timeline. Having a set of consolidated rules is very important. It is, as the Law Society and Bar Associate representatives said, it is nice to have a consolidated set of rules. Back then, they said in 2023 this would only take 1 to 2 years to complete. Now we are saying that it will only be completed in 2026 to 27. I first want to ask if we can expedite this. I believe, Chair, for having a discussion on this item, we need to talk about the issue of efficiency, right? So that's my first question. Next, on the judicial officers, We have seen an increase in the deployment of officers in the family court. I know that the Judiciary Administration has been working hard on this. And in 2027-28, the new district court building will be commissioned. It should also help with the speed of dealing with family court cases. When we approved funding for the new district court building, the Judiciary Administrator talked about the layout and the handling of the family court. And they said there will be 12 courts and 20 chambers in future. And we are only 2 years away from 2027. How can we make sure we can indeed expedite the handling of cases then? And can we also do something with the master system? Can we relax, say, the qualification requirements? Let me first declare I'm not an expert in family court matters, but I think from oversight perspective, I think we need to make sure we have a timeline. We also need to make sure we have not only the hardware in terms of the court building, but make sure we have the right manpower there. I also note the FCAMS, the Family Court Annex Mediation Scheme, is a good initiative. It was only introduced last year in March. For the 27 cases dealt with, is that a lot out of the total number of cases? What is the total number of cases? We have seen the success rate being 93%. What is the denominator again? Do you have any targets set for the next 3 years in order to achieve the right results that you intend for the scheme? Thank you. I believe the two members are also concerned about the timeline. Ms. Leung. Thank you. I understand the members' concerns on the drafting timeline of the family procedure rules. We do understand your concerns. But, as said, this is a 60-part rule and it is wide-ranging, the contents of the rules. We have been working very hard with the Department of Justice. We actually have dedicated officers liaising with the DOJ. We have also been consulting the relevant bodies, say those from the Law Society and the Bar Association. For the 60-part rule, we have already completed drafting for the 20 parts, and they have already been circulated. We believe there will be another 10 that are ready for circulation. We will need another year or so to complete the drafting. That is why we said in the paper that we will complete the drafting in 2026-27. We believe early 2027, with the completion of drafting, we will consult the public on the draft rules. We want to make sure we can compress the timeline later on. Early on, it was difficult to compress the timeline because there were some chapters that have to be drafted anew, or they are really scattered in terms of content. We need to make sure the rules are easy to understand, so we need to make sure there is a streamlined workflow for each part. And this is key because if we don't streamline the workflow, even if we increase the number of officers deployed, it will not be able to help shorten the process because they are still dealing with the miscellaneous matters before the commencement of the proceedings. We will try our best to compress the timeline, however. On the deployment of officers, we talked about in the paper, starting from 2023 till now, we have increased the number of officers deployed in terms of registrars, family judges, and family masters. We have also anticipated with the increase in the number of rooms, we will increase further the number of family judges and family masters. Right now, we have been holding recruitment exercises for family court judges and masters. And if we find suitable candidates, we will make sure to recruit them as judges. Family masters are already in the family court. We have always been looking for the right candidates with a background in family court and who have been dealing with relevant matters, we have engaged them to be masters or deputy judges. That is what we have been doing, and we will continue to do this in future. As for another question of a member on the FCAMS, we have seen this as a new scheme. We have limited figures available. We have to consult the judges when selecting the cases to refer, because the mediators are engaged by the judiciary before the integrated mediation office. When they make referrals, the cost would be borne by the users. So it is different. We still have that, and we have 200 odd cases every year that had successful referrals. So this is an arrangement on top of the original arrangement that we have. Thank you. Right. I have a question. When you talk about the FCAMS, what considerations do the judges have when they consider it appropriate to refer the users to mediation services, or the cases to mediation services? Thank you. When judges make referrals, they would need to have considered the cases to have only miscellaneous disputes that can have such disputes resolved in a couple of hours, and the users are not that emotional. The cases can be dealt with in a short amount of time, and these are not domestic violence cases. We believe with these it will be suitable for family mediation. Well, I think in general family mediation would be voluntary, right? With the FCAMS, we have referred 30 odd cases, but we have 90 odd % of them reaching full settlement. Thank you. Ms. Maggie Chen speaking for the second round. I think Ms. Carmen Khan asked some very good questions, so I would like to follow up on her questions. On mediation again. The Judiciary Administrator talked about for the FCMS, the referrals would be made by judges or masters. But they only referred 30 odd cases, and there were 20 odd cases that were successful. Did the masters have other considerations? Because from the figures, I think in 2024 there are a lot of family court cases, much more than this at least. So why were there only 30 odd referrals? Let me first declare an interest. I myself also deal with family court cases. I think there are a lot of family court cases, much more than 30. Why were there only 30 odd referrals made? That's my first question. Second, Ms. Carmen Khan asked about manpower in the family court. I know that in Causeway Bay with the new district court building, there will be 20 chambers. So is it the case that in future you would engage more family court judges? So this is my question, second question, that is on manpower planning. The third question is, the family procedure rules would have to be scrutinized by the Legislative Council. A part of them are already in effect. If you have to wait until scrutiny is done by the Legislative Council, you may have to wait until 2028-29. I'm saying, is it possible to separate the family procedure rules in batches for the scrutiny of Legislative Council, and you can implement them in phases? Thank you.
3 questions. Thank you, Chair, and thank you, Ms. Chan, for the 3 questions. First, about the Family Court Annex Mediation Scheme. It's really new. It has just been implemented. It was introduced on a pilot basis, so initially we arranged only for 1 such case per week to go through mediation, and then we plan to increase to 2 to 4 cases each week, and if that proves to be successful, we will continue to refer more cases to mediation, but only on the premise that these are cases suitable for seeking mediation. I must stress that this is a new pilot scheme. As for the existing schemes, they will continue to run parallel. The second question relates to judicial manpower for the family justice system. Indeed, upon commissioning of the new court building complex, we will increase the hardware capacity. But for software, at appropriate junctures, we will recruit judicial officers and judges. And it's not just family judges. In fact, we'll be recruiting judges at the district court level. And we'll also appoint deputy judges to meet our manpower needs. So these are ongoing initiatives. Taking a multi-pronged approach, we strive to improve the waiting time for family court hearings. As for the FPRs, indeed, they come in 60 parts. You can call them individual parts, but they are also intertwined. It's very difficult to break them down into different batches, and for some of the batches to go through electrical first. We don't find merit in this approach. Instead, we should focus on completing the drafting of the whole FPRs as quickly as possible. In fact, we are only fine-tuning certain provisions. We are not starting from scratch for some of the more practical provisions. So we'll seek to complete that as quickly as possible. Ms. Carmen Khan, second round. Thank you, Chairman. I also thank the JA for explaining the timetable for our benefit, and I really appreciate that you are given a very tricky start, and you've completed 20 parts so far. There are also 10 parts in waiting within this year, and for the remainder, I hope that they'll be ready in 2026, because after you've completed the draft, you need to go through the consultation process and submit that to LegCo for consideration. And that means the rules won't be ready until 2027. And I don't think this is ideal, because how do we level with the public that the dedicated family procedure rules won't be ready until 3 or 4 years later? I want to make sure that the completion of the rules will tie in with the commissioning of the new court building complex. The objective is to improve the family justice system, and this will also involve the use of mediation in the process. Now, my next question is this. On top of striving for early completion of the drafting in 2026, I have another question. It's about cases with a cross-boundary element. I want to know whether these rules apply or are they irrelevant, because I am considering whether mediation is a good way out, because for cross-boundary family cases, we need to have regard to different rules. So for cross-boundary family cases, if again mediation is an available avenue to help parties reach consensus, then it would be ideal. But I want to know whether these rules apply to disputes with a cross-boundary element. I'm not familiar with family law, I'm sorry. So I'd like to take this opportunity to invite you to explain this, whether the rules apply to cross-boundary family disputes. Thank you. Chairman. At present, if cross-boundary disputes are involved, and if the parties would like to take this matter to the court in Hong Kong, then we do allow mediation as an available avenue in our judiciary, and that means they are also eligible for the Family Court Annex mediation scheme. But what about the waiting time? Yes, we understand members' concern. We hope to complete drafting by 2027, in fact, early 2027. We still need to go through several dozen parts, and we'll strive to compress timetable as much as possible with a view to completing the work within 2026. However, it's difficult to compress a timetable for consultation. Now, in the drafting process, a committee has been formed comprising members from the legal sector, the relevant judges, and other stakeholders. So I hope that by the time we launch the public consultation exercise, we won't be receiving views or viewpoints that have never been discussed before by the committee, because after all, we do have representatives from the legal sector, and the views of the legal professional bodies should be sought meanwhile. So I hope that the public consultation process will not be protracted before the proposal is submitted to LegCo for consideration. Ms. Maggie Chan. Now, it is understood that the draft rules won't be ready until around 2026-27, and I note that the family masters system has been implemented for about a year, and also there is a new initiative relating to family mediation. Now, Chairman, in fact, I have a suggestion. In order to enhance the public's understanding of the progress of improving the family justice system, we should demand a regular reporting, say half a year. We should ask them to come back and report on their progress once every 6 months for the benefit of the public. Why it is so long to complete the draft? Meanwhile, of course, I understand that this is a complicated task. But as a member of this panel, I think that we also need to level with the public and give greater transparency so that we know what the progress is. So half-yearly report, please, and that more information should be provided. For example, they should tell us what progress has been made and what the milestones are and what have been achieved. We need to level with the public because the bill itself was passed in 2023. Right, thank you, Chairman. Subject to Chairman's direction, we can come back to and brief the panel on a regular basis. Only that we may not be able to report any substantive progress within 6 months. Instead, say for this topic, we have a yearly report arrangement, which may be more appropriate. Like you said, say the family masters system, after implementation, we need to observe for some time so as to accumulate actual experience for us to fine-tune the system. Well, of course, we'll be happy to come back and brief the panel in a few months' time, but that's really the difficulty. Well, let's see if we could slip this in our agenda in the future. But I do have a question. You mentioned some successful examples of cases referred by judges to mediation. Now, since you're also drafting the FBRs at the same time, will you consider devising some provisions so as to incorporate this mechanism in the rules? Thank you, Chairman. In fact, we have a chapter dedicated to alternative dispute resolution, which covers these schemes. There will be a clear delineation of roles played by judges, masters, mediators, and the rules and procedures they should follow. Ms. Maggie Chan. Another supplementary question. Now, just now the JA told us that there are different family mediation schemes. So, would the administration please give us a paper after the meeting to give a summary of all the family mediation schemes available? Thank you, Chairman. I can give you the list of services available under my purview in the judiciary, but I'm afraid I may not be able to give more information about other mediation services in other policy purviews. Right, but this is one government. You can't just talk about the judiciary's work. You should refer the matter to the Department of Justice as well, because this really shows what problem there is with mediation in the government. We're supposed to promote mediation with a joint effort. The bureaus and departments should not work in silos. So perhaps we can consolidate all the mediation schemes so that they come under one document, one letter. Right. Let me explain further. What mediation schemes are available in the private sector? Right, so you want the Department of Justice and the judiciary to give you a reply, right? You're talking about the other mediation schemes. Well, because the Department of Justice and the judiciary are two different departments. Right, we can try to write to the Department of Justice, see if they can give us a reply. Yes, please do. Because if they are not able to answer, there may be users in need of family mediation service, and the case has yet to be heard by the court, and that the services are so fragmented. But as I understand, for all proceedings, they need to go through mediation. Is that right? Not necessarily, not in my experience. Any response from the JA? Now, it's really straightforward. We can put the same question to the judiciary and the Department of Justice, and they can give us replies respectively and see what they have up their sleeve. Right, it's possible. We can write to them respectively. Any other members who would like to speak? Ms. Carmen Can.
Thank you, Chair. I speak in support the request made by Ms. Maggie Chen. With the Chairman's agreement, we should issue letters to the Judiciary Administration and the Department of Justice. In fact, the Judiciary Administrator already talked about they can provide a response on the schemes provided by the judiciary. That is, the schemes introduced in 2024 March and October, and I believe there are other initiatives organized by the judiciary. I think the Department of Justice can then talk about family mediation services provided by the Department of Justice and other government departments. I think what Ms. Maggie Chan is talking about, the Department of Justice can give a response on family mediation services provided by other departments, not other NGOs. If these are measures of the government. I think the Department of Justice should be able to provide a response. Well, I think the Department of Justice can speak on behalf of the other departments, because if we have to issue to all the departments, I don't think we'll get a response from all of them. All right, I understand your point made. There are no other members who would like to speak. I'll end the discussion on this item. Any other business? If members do not wish to propose any other business, we can adjourn. Thank you.